And happy Friday. I just want to thank you guys for tuning in with me this evening. It is Friday at 5:30. If you're familiar with the live videos, we usually go live in the afternoon around 12. But today we had a conflict come up. I had to speak on a CLE panel down at the State Bar today, so I was out of the office. And I was just going to reschedule this for another day, but a lot of people were really interested in hearing about today's topic, so I didn't really feel comfortable not doing what I said I was going to do. So I came in as soon as I got through all this traffic to sit here and do this for you. So I was trying to go live on Instagram as well, but looks like I'm having some network issues. So to the people who are going to follow me on Instagram, you're going to just have to check it out on Facebook. Today, what I'm going to be discussing is what unmarried mothers need to know as it relates to custody. If you are a dad, you should definitely still tune in, but be sure to check out my video from last week where I discussed specifically custody for what unmarried fathers needed to know. I decided to do two different videos for mothers and fathers because there are different considerations that have to be made depending on who is being represented. As I said last week and any other time I have the opportunity to do so, it is my opinion that I believe that children should have relationships with both of their parents. And both parents should be actively in their lives more than just 3 or 4 days a month. So with that being said, we can go ahead and jump into today's live broadcast. And I'm going to start just by telling you who I am so you know who you're getting this information from. My name is Attorney Joy Farrell. I'm the managing attorney here at the Farrell firm, and we're located right in Metro Atlanta, specifically in Tucker off of 285. Here at the Farrell firm, we have a large focus on the area of family law, litigation, which covers everything related to family. That's custody, child support, divorce, adoption, wills, power of attorney, etc. In addition to those things, we also practice personal injury. So if you've been in a car accident, feel free to give us a call on that if you want representation. The Farrell firm team here is very awesome. And you can head over to our website and check us out. You can find out our firm story, kind of how I started the firm, why I started the firm, and read a little bit about each of the attorneys here. And please stay connected with us by following us on Facebook, Instagram, and our YouTube page so that you can keep up with events like this. By tuning in today, you acknowledge that the information that I'm giving you is for informational purposes only, and the information that I'm giving is based on the laws of Georgia. Every case is different, and you should seek legal counsel if you need particular advice to your case. And by participating in this broadcast, you understand that an attorney-client relationship is not being created. If you've tuned into my show before, you know I like to answer all questions that are asked during the live broadcast, so you can feel free to type them at any time. I will get to them at the end of the broadcast. If by chance you are tuning into this after the live broadcast, I am not ignoring you. It's just that it's not live, but it appears to be live on your computer or phone. So if it's not Friday, November 10th, you're not watching it live, so I may miss your question. You can go ahead and drop it in the direct messages, and we'll respond to you that way. So let's go ahead and get started, and we're going to be talking about mothers today. So what about mom? So it's 2017, and let me just say I'm a mother, so I understand some of these things, you know, as a mother. So it's 2017, and it's no secret that the fathers' rights movement is on the rise, and more fathers are stepping up more than ever, and I think that is absolutely amazing. But in that process, we must not forget about the moms and what mothers go through and everything that they need to know when they're faced with a custody battle. Sorry, guys, my phone is going to ring. We're actually closed right now, so I don't have anybody to answer it. So just I'm going to turn the volume down. So moms, if you had a baby with a man whom you are not married to, if they have not filed a legitimation or signed a legitimation in the hospital, the mom has what we call sole custody rights. So if you're not married to the father of your child and you were never married and you're the mother, you have 100% custody rights of your child. When I get phone calls from mothers, they're usually pretty confused about the fact that they actually do have all the parental power. A mother typically says something like, well, I want to move here or there. I want to put the child in a certain school, but the child's father won't agree. He's telling me that I can't do this, I can't do that. And my first question is always going to be, were you married to the father? If the answer is no, the next question I ask, is the child legitimized? If that answer is no, then honestly, the biological father can't tell you what to do. And honestly, what he wants is actually pretty irrelevant, because you actually have the sole custody rights, absent of dad pursuing his rights to file legitimation, which he actually should do. But if he doesn't, he can't pretty much dictate what you do with the kids. So when I say you have 100% of the rights, sole custody, let's talk about what that means. This means you have full decision-making power and authority for every single aspect of your child's life. And the biological father does not need to be consulted about anything. Now, let me say this. Most people are clueless about this area of law, and you may already be co-parenting effectively with the father of your child, even though he does not have any legal rights. I think that is a wonderful thing, and you should always be open to co-parenting and allow your child the opportunity to have a father in their life. All I'm saying right now is that you have the final say-so on everything about the child. And if it's something you want to do, and it's something you think should happen in the child's life, and you feel like you can't make that movement because you don't have a parent who agrees with you, you don't need their permission to do anything at this point, because they have not sought those rights through the court. So right now you're free to do whatever you want. Now, if you are currently allowing your children to exercise visitation with their father, again, kudos to that. That's good, but you need to be careful, because if you are one of those moms who's practically allowing your children to live with their father, maybe you're finishing school, maybe you work a night job, maybe you have 2 or 3 jobs, or you're trying to come up in your career, and dad just has the children a lot of the time, more than half of the time, you need to be very careful with that, because that visitation history, if dad files a legitimation, it's very likely that the status quo is what's going to be the final order of the court. So, for example, if you're a mom and you say, well, I have the kids on Monday, Tuesday, Wednesday, and the dad keeps them Thursday, Friday, Saturday, and then we kind of switch on Sundays, and we've been doing that for the past 6 months to a year, you should expect that when this case goes to court, the judge is probably going to kind of keep the schedule to what it was. So if you're not comfortable doing something on a permanent basis, don't even do it on a temporary basis. Now, in 2017, a mother should not assume that she will automatically get custody in any custody case just because she is the mother. There is no presumption in favor of a mother. This means that at the beginning of a custody case, a mom and dad have equal opportunity to have custody of the child. When in a custody battle, the 2 types of custody that are going to be discussed is the legal custody and the physical custody, and there's going to be no presumption that mom should have either of those. You're going to have to fight your way through court to prove that you should have whatever it is you're seeking. So if you're served with a legitimation petition, the father is seeking custody rights, legal custody and physical custody. Legal custody is the ability for him to also be able to make those decisions that you've been making traditionally on your own about the child's education, about his or her medical needs, about the religious upbringing, etc. So dad is trying to get an equal standing to be able to have say-so about those things, and that also includes extracurricular activities. The physical custody is the pursuit of who the child will actually live with and how often they will live there. The most common concern for mothers in these cases is the physical custody aspect. I know it's scary because you've been the sole parent for a number of years, and now all of a sudden the dad wants to come in and have this set time with the child. It's important to understand that just because a dad is seeking to legitimate, that you understand that it doesn't mean that he's necessarily trying to take your child from you, and you shouldn't go into a panic. Once the legitimation is filed, you will have the opportunity to tell the court your side of the case and tell the court what you think is best for your child. However, it will always be a safe bet for you to hire a lawyer if you fall into that situation, especially if the father has a lawyer. I've had too many clients that come here on the back end, dad filed for legitimation. Mom didn't think she needed to get a lawyer because she assumed, hey, I'm the mom, I'm going to win. I don't need a lawyer. I'm not going to spend the money. Dad gets a lawyer. They go to court. Mom walks out with weekend visitation, and now she's in an uproar because she doesn't have custody of her kids. So never go into a custody action without a lawyer. So once the case goes to court, once the case is over, the judge will enter a parenting plan for mom and dad. And what the parenting plan is going to do is going to guide the mother and father as to which days of the year each parent has a child. And all 365 days of the year must be accounted for pursuant to Georgia law. You can't just have some days. Every single day of the year must be accounted for when doing a parenting plan. So that way, if there's ever a dispute, mom and dad can pull out the parenting plan, open it up, and say, okay, here's what day it is. Based on the plan, this is who's supposed to have the child, etc. Now, let me say this. Sometimes legitimations go in. Sometimes we have a parenting plan put in place. And then sometimes we may not have a dad who actually exercises the visitation that he went to court to get. And so, but what we do have is a parenting plan out here giving this dad time that he never uses. And sometimes years can go by. But then all of a sudden, one day, dad pops up at the door, 2 Christmases from now and said, hey, it's my Christmas to have the kids. I want to take the kids with me. And if that parenting plan gives him that time, it is his time. So what you need to be thinking about as a mother, if you have a legitimation that is in place or going to go in place, and you have a father who stops exercising visitation, does not come see the kids how he's supposed to, you need to be considering filing for a modification of that visitation to change the order so that he doesn't pop up in 2 years on Christmas morning demanding that he can take the kids for the next week when the kids haven't seen him in 2 years. So you want to be very mindful once this parenting plan goes in place. It is the order of the court until you change it. So anytime somebody's not following a parenting plan and they're not exercising the time in that parenting plan, after, a fair amount of time, you want to just say, hey, let me go ahead and modify this so we don't have any issues coming up in the future. Now, I'm talking about what's the end result of a legitimation action. I do want to note that just because a father files a legitimation petition, it should not be assumed that it's going to automatically be granted by the court. And that is a mistake that a lot of attorneys make and fathers make. And they think that it's an automatic right to be able to pursue a legitimation. Legitimations are not always granted. In order for a father to be able to legitimate the child, the first determination that the court has to decide is whether or not the father has abandoned or waived his opportunity interest to be in the child's life. So when we talk about waived opportunity or abandoned opportunity interest, we're trying to determine whether or not the father waited too long to try to be in the child's life. So for example, if you have an 8-year-old son and the father hasn't been around all of these years, and all of a sudden he pops up because you file a child support case, and now he's saying, hey, I want to file this legitimation. If I'm paying child support, I'm going to be seeing my son A, B, C, and D. And now you're all concerned because he's coming for custody. Well, if dad waited 8 years to be in your child's life, and the only reason he's actually trying to do this is to avoid child support, I would most certainly argue that he has waived his opportunity interest. And courts have found as young as 3 years old to have waived that interest. Every fact is different. In some cases, I've seen a 5-year-old case, a 3-year-old case, a 7-year-old, a 9-year-old. So varying factors, but you definitely want to, if there's a concern with the relationship between the father and the child, you want to make sure you have counsel to make sure that legitimation doesn't automatically go through. Because if you're not there to make that argument, most judges will just say, hey, whatever they want to legitimate, we'll let it happen. After it's determined whether or not the opportunity interest has been waived, the other factors the court looks at, number one is dad a fit parent? Is he normal? Is he operating? Is he on drugs? Does he have a place to live? Is he fit? Does he have common sense, etc.? Let me not say common sense because you don't have to have common sense to be a parent, but as long as he's an okay person. And then we look at if it's in the best interest of the child to then be legitimated as a child of that man. So after with legitimations, once, sometimes we have mothers who are opposite. They're not trying to stop a legitimation. In fact, they want nothing more than to have their child deemed legitimate and to have the father be an active role in the child's life. And they contact me saying, hey, I want to get my child legitimated. I want to set up a visitation schedule for the father. What do I need to do? Well, unfortunately for mothers, only the father can bring a legitimation action. Being in a child's life is a legal right. It is not an obligation. So therefore, the father is free to choose whether or not he wants to exercise that right. If he wants to be in the child's life, he can file legitimation. If he doesn't want to be in the child's life, he does not have to file legitimation, and there's nothing you can do about that. However, although a father has the right to choose whether or not he wants to be in a child's life, exercising visitation and custody rights, what a father is not free to choose is whether or not he will provide financial support for a child. A mother can still pursue a child support case even if a father has not legitimated nor has any intention to ever legitimate the child. Seeking child support is the right of the mother and the child, and it is not indicative of a legitimation action being filed. So that's one thing for moms. Sometimes they don't realize that they can go and file the child support case even if dad isn't there, if dad's never been there. Even if dad is there, you can still file for child support just to make it official and to guarantee that you get it every single month. So I think that's enough information today for you moms out there. So if you have any questions, I want you to go ahead and start typing them below, because I'm going to spend a few minutes answering the ones that I see. And then once I answer them, I'll give you guys my phone number so you can call us if you want to schedule an appointment. Okay. Valerie says, what if the father is behind on child support? Valerie, I'm not sure what part of the video you made this comment, but the father being behind on child support has nothing to do with him being able to file for legitimation or get custody rights to the child. If he's behind on the child support and there's an order in place, then you should file to enforce the child support order by way of contempt. Jennifer says, if the dad filled out all the paperwork at the hospital and signed the birth certificate, is that considered legitimation? Very good question, Jennifer. So depending on which hospital and when your child was born, hospitals have paternity acknowledgement. And then under that is a thing that says legitimation acknowledgement. So if dad signed both of those, then what he did is called an administrative legitimation. So the child is legitimate, capable of inheriting from the father. But with the legitimation, the administrative legitimation does is just that. It doesn't assign any custody rights or visitation schedule. Administrative legitimations were valid in the state of Georgia from 2008 until July 1st, 2016. So if you had a child born between that short window, it's a possibility that the father signed the administrative legitimation. If you want to know, check with your Department of Vital Records and see if they have it on file. If you have a child born after 2016, that was not an option. Even like I said, if the child was not, you still need to pursue the custody actions. And out of safety, if you don't know, then I would still go with the filing the legitimation. JoJo says, my son dad is trying to get me served and I went to court. Case got dismissed because he didn't get our son legitimized. We moved here to Georgia and we're not together anymore and only want the child when he wants to get them and not give me any child support. Child support is trying to serve him and they have not been served yet. So JoJo, it sounds like dad is trying to serve you. You got the case dismissed. I'm not sure what he was trying to serve you with exactly, but he would need to serve you with legitimation papers here in Georgia if the child was born out of wedlock to establish the visitation and custody schedule. With the child support, the hardest thing for the Department of Child Support Services to do sometimes is to actually give notice to the father because it's very easy to dodge. You may want to consider contacting private counsel like us, and we can pursue him a little bit more aggressively than Child Support Services has the resources to do, especially if you know where he lives at. But you can't get child support without making service, so you need to make sure they track him down. Erica says she needs an appointment. If you need an appointment, you can reach us at the number that I am putting on the screen. There you go. Okay, so Stephen says, sign the birth certificate doesn't give you rights. Yes, Stephen, tell the people, sign the birth certificate does not give you rights. And I went over that last week. Sign the birth certificate does not give you any rights. It doesn't mean anything other than you're saying, hey, that's my sperm that made the baby. I think I'm the biological father. It does not give you any rights whatsoever. So do not walk around saying, but I signed the birth certificate, because it means absolutely nothing. Joanne says, when is it too late for legitimation? Joanne, it depends. Every case is different. Like I said, some cases out there have 3 been too late. I read one today. It was about a 5-year-old, and I read another one about a 9-year-old. So it's going to be the circumstances surrounding the relationship with your child. If you are thinking about filing legitimation and want to make sure you're not waiving that opportunity, then you need to make sure you're paying mom some money. You need to make sure you're trying to see the child, send the child birthday cards on the birthday, send birthday gifts, send Christmas gifts, and make sure you're documenting it, showing that you actually do want to have involvement in the child's life. And if you can't afford a lawyer, you can file pro se. Like, don't let not being able to afford a lawyer cause you to miss the opportunity to be in your child's life for the rest of his life because you don't have a couple of $1,000s. Jojo here again, he abandoned our child. He's 2. Since he didn't have support here, I have to send my child to grandma to get help and work. Jojo, be careful about sending your child to your grandma because you're going to have a grandparent custody case coming up on you possibly. Justin again saying, when is it too late for legitimation? Like I just said, every case is different. Don't wait too long though. And if you're not going to file, make sure you're being a part of the child's life by sending some money. Never send cash, checks, or money transfers from your bank account and label it child support or for a baby's birthday. Stephen is on here trying to educate the people. Child support and legitimation are 2 different things. Yes, sir. They are. Sherby says, can visitation be reversed and how long does a visitation last? I wouldn't use the word reverse. The word we use on the legal side is modified. It can be modified at any time that you feel like you have an argument to modify. You file the petition, take it before the court, and the court can make a determination of that. However, if there's a visitation order in place and is not being modified, it lasts until the child reaches the age of majority. So that's once the child graduates high school. Hi, Rhonda. What if the mother and child live out of state and the father is a Georgia resident? Would the mother file in their home state? Rhonda, are you talking about for child support? Because mothers can't file legitimation. So if a mother is seeking child support and the mother lives out of state, she would have to file here in Georgia if the father lives in Georgia for child support. If a father is wanting to legitimate and the mom lives out of state, the state of Georgia permits the father to actually file in his home county. However, the court can just simply legitimate. They can't lay out those custody and visitation factors without having that personal jurisdiction over the mother. Chantel says, my brother's baby mom put him on child support because he wouldn't agree to take care of her. Now she won't let him see the baby at all. He makes $500 a week and $250 goes to child support automatically. She's constantly texting him disrespectful paragraphs and tells the child he doesn't love her. What can he do? He can barely survive on what's left of his check. If he makes $2,000 a month, paying 50% of his income to child support is completely not accurate. So you may want to have him come in and do an appointment to see if he can get a child support modification, number 1. Number 2, he needs to go ahead and petition the court to legitimate the child so that she can't control when he gets to see his child and when he gets to talk to his child. Custody orders also put provisions in there so you can have the right to call your child. So just because you don't see them every day, you should have the opportunity to be able to call them on the phone. And a lot of orders now include things like FaceTime. So you can FaceTime the child. Jojo, how long does it take to be granted? I think my son's dad filed for it. I think he's trying to serve me, which I haven't yet have receipt papers. Jojo, don't avoid service on a custody action because people can serve you by publication, or sometimes people are shady and it look like they serve you. They go to court and he walk out with full custody, and when they come pick your child up, you're gonna be looking crazy. So go ahead and get served, face it head on, and deal with the situation. There's no need in running from it because you can't run forever. So go ahead and deal with it. It takes a couple of months, depending on what county you live in, to go through the process. 4 to 6. Slower counties, maybe even up to a year, depending on what's going on. But don't ever avoid service on an action, because we can make service as lawyers. We can make service in another way. And because you chose not to be a part of the action, we pretty much get whatever we want if you choose not to be there. Pangela, if the father moved to another country, if he wants to legitimate, he would still have to come back to Georgia to do that. Eric, the truth. Eric, I want you to go on my Facebook page and look for the video I did last week. Custody for unmarried fathers is going to tell you everything you need to do to get legitimized. Easy way is just come hire me and I'll do it for you. And speaking of that, Justin says I make this look easy, because it is easy for me. This is what I do every single day. This is my passion. This is what I love. I love doing this. Valerie says, how can so many fathers get away without paying child support? Well, why do so many mothers let them get away? I mean, it's a two-way street. Trust me, my husband, I love him, but if he had to pay me child support, I'm coming for my coins, all of them. He's not gonna get away with that. So don't let him get away. Make sure you enforce it. Don't sit back. A lot of times moms can be like, well, I don't want to put him on child support. I don't want to be, whatever. Get your money. Kid's expensive. Jojo says, can I give grandma temporary custody since he with him? Jojo, you can, but I would advise you probably not to do that. What we could do, though, is give what's called a grandparent power of attorney. And that way your mother has the authority to, put them in school, take them to the doctor, and do stuff like that. And you can revoke that power of attorney at any time versus actually filing the custody action. And then a judge would have to be the one to revoke it. So that may be something that's better for you. And it's way, way affordable compared to a custody action. Nisi says, what if father acknowledged paternity, signed child support order years ago, and now wants to legitimize? That's fine. Acknowledging paternity, that's cool. If he's on a child support order, that means he's paying child support. And so he has a good argument that he hasn't waived this opportunity to be in a child's life because he's been providing financial support for the child. So that would probably be okay, I would imagine, if he's tried to have any other relationship. Larisha, my son is a month old. When can his father be put on child support? The day the child was born. So go ahead and file that petition. Steven says, question, you end up doing a settlement agreement and we or the mother doesn't say anything about it, about after school care. Can she go back for modification for after school care if she already getting child support and there's a settlement agreement in place? So, Steven, when these situations, it's very important at the time of the agreement that you consider all the factors of the child, because you just can't be going back because you forget stuff. I mean, technically, it's a change in the needs of the child, but technically it's not because it existed at the time of the original order. So I would say we're not changing it. Child after school care existed at the time we agreed on child support. So deal with this agreement that's in place. Make sure when you're talking about a settlement agreement, you're talking about an official court order signed agreement that's been incorporated by a superior court judge, made an order of the court so that it is enforceable. If you're talking about something y'all sign on your own, that's like good as nothing. Tiffany says, what to do if child father has had no contact with the child for 3 years and the child was born in 2008 and dad signed the administrative legitimation for the child and lawyers' fees are too much to pay to seek full custody. So he did the legitimation. So if he's not in the child's life, pretty much what that means, if dad dies, your child should be able to inherit any benefits that dad has. He's going to be considered a legal child and an heir according to the laws of Georgia. For dad to actually have custody rights and determination, he still needs to petition the court, and that petition would be a petition for determination of custody and visitation rights. In the event he does that, like anytime soon, and he hasn't seen the child in 3 years, I would file an objection to that and say that, he shouldn't have visitation. He doesn't have a relationship with the child, but we can't change the legitimation if it's already in place. Melba said, child, I have 3 kids born between 94 and 2001, DeKalb Medical, Atlanta Medical. Do you know DeKalb in Atlanta, girl? Probably not, but you can check. And those kids were born a long time ago, so they weren't within the administrative legitimation phase. Laquana, my daughter is 3 and her father has been incarcerated since she was born, looking to be released in mid-2018. If he ever decides to gain custody, can he and what can I do to prevent the issue? The father name is on the birth certificate. Yeah, he can still seek custody, Laquana, just honestly, because he kind of has an explanation for why he hasn't been in the child's life. I feel like the case I read today, I feel like that was incarcerated. In the court in that case, denied the legitimation for a couple of other factors, though. So, I mean, if he's in jail and he's not trying to send the kid cards and stuff, there's the possibility it can be waived. But depending on what he's doing time for, it may or may not be relevant to the custody issue. You just kind of have to see when he gets out. But just because he signed the birth certificate, he doesn't have rights, so he can't come to your house and do anything. Julia says, what happens when your ex changes jobs and the child support arrear stops? Who should I contact? Julia, it depends on it. If you're getting paid via income deduction order, meaning a garnishment from the paycheck, you need to make sure the new employer has the income deduction order. And all they do is you just need to get a copy and send it to them. The other employer should have sent it, or your ex should have made sure he had it, but your ex is still liable for all the missed fees. So just make sure the new job has the income deduction order. In the meantime, you can still file a contempt for the money that he hasn't paid. Valerie says, if the father's on disability, can you get support? In some situations, Valerie, you can. We need to dig into the specifics on that, because the federal law does prohibit one type. So we'll have to talk about that. DeMac, can the father move out of state with the child if he has primary physical custody and the mother has secondary physical custody? So DeMac, in that wording, it would be, it sounds like a shared custody, even though you're being categorized as primary. I mean, primary person can technically move her if they want to, but on the secondary physical custody, I would be concerned, like, what is her parenting time? Is it like a couple days every week, or are we talking every other weekend? But the primary physical custody, custodial parent can move wherever they want to, unless your order says something differently. But Georgia is not a state that prohibits you from moving. Like Texas, you can't move out of Texas without court permission. You can't move out of Louisiana without court permission. You can't move out of Michigan without court permission. Georgia, you can go wherever you want to go. Y'all got a lot of questions there, y'all. Making my throat hurt. Nadia, my daughter's father and I lived together for 5 years. We live a rather good life. Our daughter attends a private school and he was extremely abusive, and I decided to leave. My question is, can I ask in court that he helps me with private school expenses or child support? Have to go towards that. Absolutely, Nadia. So tuition in private school is one of those discretionary expenses that a court can put in a child support order. And because you and father established this lifestyle for your daughter, and she was already in private school when you were together, you can most certainly make a very strong argument to the court that she should be allowed to stay in private school with the financial help of her father. And I am sorry that he was abusive to you, but I am glad that you got out of that relationship. Nisi, 10 years later after he already announced paternity. Nisi, I honestly forgot your original question. I'm sorry. But there's always a case to be argued, especially with a good lawyer on the other side. You should never assume that there's no case. What if the child's father had the child for 2 years? Father just took the child and wouldn't return her. He put the mother on child support, and the child was taken by defects from the father because he abused the child, and the child is now with the mother, but the child support is still coming after her, even though she has had the child for a year. How can she stop the child support from coming after her? So this is an excellent question, Sharita, because this happens so much. So sometimes custody changes, and nobody files a modification of the child support. So what needs to happen here is there needs to be a petition filed to stop the child support. Sometimes if it's through child support services defects, you can just let them know, hey, I have the child. They may stop it temporarily, but the official way to stop it is to actually file a modification of the child support order. Okay, I answered all that. I answered that one already. Trebor, is it possible for a mom and dad to sign a parenting plan outside of court, or should it be filed as an order? You can sign whatever you want to out of court. What does that mean? Absolutely nothing. Everything needs to be an order of the court, or else it is not enforceable. And so you can't just file a parenting plan with the clerk and be like, hey, here's our parenting plan. It actually has to be a part of a case, and it has to be a final order on custody. Lisa says, my ex-husband and I constantly stayed in court for contempt over 8-year period. Every time he got 60 days later more, I would file a contempt order, then brought my attorney in, and he would have to pay my attorney's fees. Child support enforcement is a joke. I encourage everyone to have a family court. Oh, absolutely, Lisa. I preach that all the time. Absolutely. Sade, how does filing for back child support work? I believe Georgia law, as long as he has paid for something within 30 days. And so the pay for something within 30 days, Sharmar, applies to our abandonment, our criminal abandonment for lack of support for a child. So if he's paid something in criminal 30 days, he has not abandoned the child. Back child support can be interpreted in a couple ways. Back child support, in my legal interpretation, is support that you have not been paid, that you should have been paid via a court order, and then you can just pursue that through a court action. Janet says, child support was issued in divorce and order has been administered by state agency. May I go through an attorney to petition for an increase? Yes, you can, Janet, as long as you've met statutory timeframes, the 2-year wait period, or substantial change in income, or if this is the initial modification, you can go ahead and do it. Son's dad has health insurance but won't give me the health insurance information since I have full rights. It is, I don't know why he's doing that, JoJo. It is absolutely no point in paying health insurance and you're not going to give the mother access to use the health insurance. That's a waste of money. Go ahead and get your own insurance. And he'll just, when you file for child support, he'll have to pay more child support since he want to play those games. Tracy says, how long does it typically take for child support to find out where the non-custodial parent is working to start up the child support again? Even though my child's father works, he does not have the best ability. Just as I'm getting used to getting the child support before I know it, he stops and never tells me where his new job is at. Child support makes no effort in finding out if the other person is working. They're a state agency. They have 500,000 cases. They won't. That's up to you to get that information. Super bad. Shay, what rights does a father have for children born before marriage and the birth certificate is signed for one and not the other, as well as the mother not allowing the father to speak to the children? So if he married the woman that he had a baby with and they had the baby before marriage, the child is automatically legitimated. If this is not what you're talking about, what rights does the father have for children born before marriage and the birth certificate is signed for one and not the other? Birth certificate doesn't really matter that much. Clarify your question for me, then maybe I can answer it better. Brandy says, my kid's father is in Louisiana. He's ordered to pay child support, but hadn't made a payment since 2012. I stay in Georgia. They keep telling me that they're waiting for Louisiana to force the order. What can I do? That is absolutely true. That is Louisiana jurisdiction, and that is unfortunate. I'm sorry. Larisha says, if I have a child support order out of Fulton County, he is $14,000 behind, but for the past couple of months, the court date keeps getting rescheduled because he won't show up. But he is working and getting paid under the table, and the court doesn't know he can get away with this. Larisha, you probably need to get a lawyer if you don't have one. If you have one, tell your lawyer to do a third-party subpoena of his bank accounts and do some other things to find out what his income is and not let the court keep moving the court date. Ask them to enter an order of incarceration and put a warrant out. Laquana, father in jail for drug gun charges and violating probation, looking to be released in 2018. Okay, drug and gun charges, although they don't sound that great, they're not like abusive children or anything like that. So there is a possibility that he can still pursue custody. You may want to do supervised visitation or whatever. I'm sure he can't have any guns with the felony charge anymore. But you may want to do supervised for a period of time, but he will have the right to bring it. You would just have to fight it. Barbara, this is a great question. If the father files bankruptcy, does he no longer have to pay child support? Bankruptcy, bankrupt everything except for child support and student loans. Okay, so the two things everybody want to get rid of. So he can file for bankruptcy, but he still has to pay that child support. Erica, the truth, my baby mother stays out of state, but if we both take care of the children, can we both file for the child in our taxes? So what the law is, Eric, is that the person who the child resides with primarily is the person who claims the child on taxes. A lot of times the child support paying parent feels like they should be able to claim the child that they pay child support. However, for looking at the federal laws, the person that the child resides with, and if you don't have rights to the child, you absolutely don't have rights to be filing on the taxes. And let's say you did do a legitimation, but mom had primary custody. it is mom's absolute right to file the child on her taxes. And you can't even ask the judge to allow you to claim the child every other year, because the courts don't have the authority to change a federal law, which is the primary parent claims the child. However, mom could give you permission to claim the child, but she could revoke that permission if she wanted to. Tarasha, I have a 15-year-old who is not legitimized, that has not paid anything in 9 years due to being in and out of prison for drugs. Currently in prison. Seen her once in 14 years. If I file for child support, what are the chances that he'll get visitation? I would pretty much, if what you're saying is like factual, I would say that he would get no visitation whatsoever. Is he still in jail? Okay, he's out of prison. Okay, yeah, you can file for child support. Yeah, he won't get any. I don't think he has a good case for custody unless there's something you're not telling me. I don't think he has a good case. When do I take father's calls? I did a video last week for fathers, and most weeks I do it for both mothers and fathers. But you can go back on our Facebook page or our website and check out the videos there. Andres, I have a 14-year-old, 18-year-old woman that come off child support. And how, when they graduate high school, and it depends on what your order says. So you have, your order is going to have to be modified, especially if they're the same mom, because they're probably on the same child support order. So you're just paying a flat rate for both kids. And so one's going to graduate, you're still going to be paying this $600 per month. You need to file a modification in the change of circumstances that one child has aged out, and then just pay it for the 14-year-old. So you'll want to go ahead and get that started so that you're not paying unnecessarily over the price, and you shouldn't have to. So you just need to file a modification. Ashley says the parent only paid $98 instead of the court order $450. Can a parent file contempt of court? He has a job, but he's getting paid on the table. So should he have no problem if the other parent asks him to take a job? Blah, 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 blah. Yes, you can file for contempt. He still owes you the other almost $350, $352. He still owes you that. Yes, you can file for contempt. The standard for contempt is whether or not it's willful contempt, and so you would definitely want to get a lawyer so we could do some background research to confirm to the court that he had money and he didn't pay it, i.e. he paid his car note, his car insurance, he paid his rent, but he didn't pay his child support. Nobody's going to believe he gets all that for free. Husband lives in poor living conditions. We are divorced. He has visitation rights every other weekend. If living conditions are poor, does he still have visitation? Yeah, he does. I'm assuming his living condition got poor after the fact. So if you have a true concern about it, you should probably file something. But it needs to like legit be poor living conditions, like not just something, you may turn your nose up to, but it needs to be like power not working, so they don't have food in the refrigerator type of poor living situations. Nisi says, is there a limit of how much arrears can be recovered? No. Quisha, I was awarded temporary custody of 3 kids, and my 15-year-old wants to live with his father. I have an answer for that, but I'm not going to say it on here just because his dad might see it, and that won't help you. So come into the DMs, slide into my DM, and I'll give you that answer. My daughter turned 18 and became emancipated, but my monetary obligations stayed the same because I still have a son under 18. Is there anything I can do? Yes, you need to file for a modification ASAP. Tracy says, my father is in the arrears and he has another child. Do I get his tax return files? If Child Support Services is enforcing it, they do have the option to garnish his taxes, but it's not automatically. You should talk to them about it. Superbad says, my brother has 2 children with a female. They got married after the kids were born, so that means they're legitimated. Yep. So they're going through a divorce. So right now he has equal rights as mom. It shouldn't be assumed that mom has rights. Him and his wife have the exact same joint legal custody, joint physical custody right now. So he needs to make sure he has a divorce lawyer to address those issues. Andrea says he just lost his job. Can I file for child support? You could, but I will wait till you get a job back. Just be patient if you can. Need to set up a time. Okay, I'm put the number back on the screen while I scroll so y'all can call or go on the website. What happens if I have primary custody? Oh, wait. I already read that one. Marquita says if the child is 18 and still in school, does dad have to pay child support? Yes. Up until high school graduation or 20, whichever one is occurs first. Davey, I shouldn't put your question on the screen. That was low-key ignorant. Okay. David, my wife and I have a daughter that was legitimized by my wife's ex-boyfriend. Hold on. My wife and I have a daughter. Okay, that's just a boyfriend. He has not seen our daughter in 5 years and she is 7. We want to change her last name to mine. Can we file for abandonment? You could. I mean, if he hasn't provided any support, but what you may want to be considering is a step-parent adoption versus just changing the last name. That's something to consider. Ray, I just practiced in Georgia. One of my daughter graduates in May. My ex is obligated to pay an additional $200 per month for swimming. Once she graduates, can I take him back to modify the amount for our other daughter? Yes, you can. Yep, you can always modify. Okay, I feel like I hit all the questions that were posted. So that was great, guys. Y'all had some really good questions. I appreciate it. And I can tell I'm getting a lot more participation on the evening broadcast. So maybe I should go live more in the evening when you guys are not at work. So I'll have to consider that. But I really appreciate you guys for tuning in today. If you want to schedule an appointment to meet with me or one of the attorneys here in my office, we're all very awesome. You can call us at 678-973-2803, or you can go to farrellfirm.com and book online. The consultations are not free. They are $150, and they give you an hour with one of the attorneys here in the office. We're located here in Tucker, Georgia, off of Lawrenceville Highway 285. So right off the perimeter. Again, thank you guys for tuning in. I hope you have a wonderful and blessed weekend, and I will see you guys next week. Bye.